I'm Drew Stevenson, and this is a lecture for my administrative law class about the Freedom of Information Act, and specifically FOIA Exemption 7. I know in most of my videos I'm covering 2 exemptions, but Exemption 7 is very long. It has subsections A through F, so it gets its own video. But all of this is about law enforcement records. For my students, number one, the 9 FOIA exemptions are the most important part of FOIA to learn, more important than any of the cases. I'm going to talk about one Supreme Court case here just for purposes of illustration. You actually don't need to read the case. You do need to learn the kinds of ins and outs of FOIA Exemption 7, though, and the things it applies to and its scope. And so let's look here. Again, we're talking about law enforcement records. And in some sense, this is a pretty easy one to, I think, get your head around, or is fairly obvious that if the FBI is investigating you, you shouldn't be able to do a FOIA request and figure out who their confidential informants are, or what goods they have on you so far, and so forth. So here we go. Records or information compiled for law enforcement purposes, but only to such an extent that the production of such law enforcement records or information, A, could reasonably be expected to interfere with enforcement proceedings. And so if it's reasonable, now they're always going to say that law enforcement, that this is going to interfere with their investigations, but they're going to have to probably explain a little bit, or at least generally to a court, why, and seem reasonable. And if they want to invoke the FOIA exemption and not make a disclosure when there's a FOIA request. B, it would deprive a person of a right to a fair trial or an impartial adjudication. If you can imagine that you have an enemy who's under investigation and you want to publicly shame or humiliate that person, so you do a FOIA investigation of what some law enforcement agency had on them so that you could use it to humiliate them, or to create a lot of public disdain for the person so that it makes it hard for them to get a fair trial, and so forth. We don't want that. Okay, C, it could reasonably be expected to constitute an unwarranted invasion of personal privacy, right? When law enforcement does investigations, you've watched the movies and cop shows, they talk to lots of just innocent bystanders who are witnesses, and we don't want those people to come under scrutiny or get unwanted attention. Could reasonably be expected to disclose the identity of a confidential source. This is our confidential informant protection, including entities, state, local, or foreign agencies or authorities or private institutions that furnish information on a confidential basis. And in the case of a record or information compiled by criminal law enforcement authority in the course of a criminal investigation, or by an agency conducting a lawful national security intelligence investigation, so Homeland Security or some of our other federal agencies that are worried about espionage and national security, any information furnished by a confidential source. So let's take a break here for just a second from the slide and remind my students, if you're a defendant facing trial, then we have a Supreme Court case, Brady v. Maryland, that requires that the prosecution, under due process concerns, has to turn over anything material that that you could use in your defense, basically, that would help exonerate you, or help with mitigating your sentence. We have an ethics rule under the ABA model rules of professional conduct that's even a little more demanding on prosecutors, and says prosecutors have to turn over to criminal defendants anything that even tends to negate guilt or mitigate guilt. And so if you're a defendant in trial, hopefully you're getting this information. You don't need a FOIA request to get it. What we're worried about is people are using FOIA requests either while they're under investigation to figure out like what the authorities actually know so far so that they can plot accordingly, or people will use it, let's say someone was investigated and they decided not to bring charges even though there was some wrongdoing or some embarrassing conduct there. And so that person's political enemies or personal rivals might try to get that information so that they have dirt on them, essentially. And so we want to prevent that, and we want to do things that keep law enforcement. We certainly don't want organized crime to do a FOIA request and get a list of all of the moles or confidential informants. We don't want someone to get a list of CIA assets or undercover operatives in other countries and so forth. E and F, we're almost done, I promise. E, it would disclose techniques and procedures for law enforcement investigations or prosecutions. Imagine like the time that police go on and off of shift, like the classic Hollywood plot twist, right? That's when they always stage their crimes. Or would disclose guidelines for law enforcement investigations or prosecutions if such disclosure could reasonably be expected to risk circumvention of the law. In other words, if you know that the police aren't going to go more than 50 miles from their precinct without getting special approval, or that that they're not supposed to draw their weapon unless certain magic circumstances arise or something like that, then that could be useful and someone could manipulate that. F, and this is the obvious one, could reasonably be expected to endanger the life or physical safety of any individual. Obviously, we're not going to let you use a FOIA request to find out who's in the witness protection program. Okay, here's a case. I know this is an old case from 1978, but it's a US Supreme Court case that's pretty famous, and it's in my administrative law casebook. For my students, I actually don't care if you read the case, or if you do, you should just skim it. I'm going to tell you what you need to know about it, and it's really just there to illustrate Exemption 7. And this is the National Labor Relations Board versus Robbins Tire and Rubber. The company, Robbins Tire and Rubber, was kind of in trouble with the NLRB over unfair labor practices. Basically, the management and the union were at an impasse and had a dispute, and the union had made a complaint about the management violating the law to try to do union busting or something like that. And so what they wanted was, the NLRB had talked to a lot of witnesses in the company, probably people in the union and people in management, and the company wanted, before the hearing, all the witness statements that the NLRB had. Well, the NLRB doesn't want to turn that over, right? They're not going to call a lot of these witnesses, and they're worried that they will be subject to either retaliation or pressure to recant their statements and things like that before the hearing. Now, note that the court notes that in this case, Congress had, just before this, and again, this is in the 1970s, had amended Exemption 7 actually to make withholding information more difficult. And that it actually had to show that it would interfere with enforcement proceedings. But what the problem for the NLRB was that they were having a hard time articulating how, since they were about to go to their hearing, how this would interfere with this enforcement proceeding without revealing the content. And do remember, with these FOIA litigation cases, sometimes the parties who have done the FOIA request, it's still worth litigating, because even if they don't get disclosure, the agency might have to articulate a fair amount about the content of what they don't want to disclose to justify their invocation of one of the exemptions. So you might walk away with something useful just by making them go to court and defend their invocation of the exemption. And the court here held that this is not a case-by-case rule. The agency doesn't have to show that disclosing this would interfere with this proceeding, just that if they always have to do this, turn over witness statements, it will generally make their lives miserable, make proceedings more difficult, and interfere with other proceedings. And so that was enough to satisfy the court for purposes of Exemption 7. And I think that's enough to satisfy your curiosity about Exemption 7. So I'm going to wrap up this video about FOIA Exemption 7. Make sure you watch the other videos on, there are 9 total on the other 8.